Okay, today is Thursday, October 14th, 2021, and we're going to be talking about judge-made law and the role of the judicial branch in interpreting the law. So we're going to begin on page 3, sources of law. So last time we kind of ended up here, and what I want to get into today is a little bit more detail about how a court goes about deciding a case and creating judge-made law, common law, case law, precedence, various different words that kind of mean the same thing. As you'll recall from last time, when we use the term common law, the traditional sense referred to the law that carried over from English common law to the colonies prior to the United States, and then carried over post-Revolutionary War and adopted by the courts in the United States when there was really no other U.S. law that they could rely on to decide a case. So over time, common law has become less relevant, although it is still used even today, hundreds of years later, by courts when they look at novel cases or precedential cases. So even today, we still have some influence, or quite a bit actually, of common law within our system. So now the more modern meaning, or sometimes used when we say common law, is this area of judge-made law that is developed after hundreds and thousands of cases have been decided over the years, which develops this huge body of law that we can research as lawyers and judges when we're making legal arguments in court. So to begin with, let's talk about how this occurs. So I'm going to flip back over to the page we looked at the other day. Okay, this is here. Page 12. Now you'll remember we looked at this page the other day, and this is an Oregon statute. This is ORS, or Oregon Revised Statute 163.175. So this is a statute that was adopted by the Oregon legislature originally back in 1971, and this is a criminal statute. This would also be, if you'll remember from the beginning of the term, when we talked about categories and classifications of law, we have civil versus criminal. So this is a criminal law, and we have procedural versus substantive. So this is actually a substantive criminal law. And what I mean by that, substantive law is law that provides a definition, a numerical amount like a speed limit or something like that. Procedural law, if you remember, the steps that have to be followed to do something. So typically that refers to court procedures or things like that. So this is a substantive law because it gives us the definition of the crime of assault in the second degree. So that tells us what is the definition for that crime. That is the substance. So just to kind of give you some background there. It's a very common crime, actually. So let's take a look at it. I want to focus on letter B, which is probably the most common way that this crime occurs. So a person commits the crime of assault in the second degree if the person intentionally, meaning they do it on purpose, that is their goal, their intent is to commit the crime. Or the alternative way is knowingly, meaning you know that the action that you're engaging in will lead to the result. We're not going to get into, in criminal law, there are various different mental states. That's beyond the scope of this class, but that's where that comes from. So it's not an accidental crime, is what I'm getting at, okay? So intentionally or knowingly cause physical injury. So physical injury, a bruise, a cut, a scrape, something that's not permanent. It's something that will heal. If it's something that will not heal that causes permanent impairment, that's a higher level crime, or that's a serious physical injury and may lead to a higher level crime. To another by means of a deadly or dangerous weapon. Okay, so remember what we're talking about now. We're talking about the role of the judicial branch, a judge. And part of the job of a judge is to interpret the law. Now what I mean by that is the judge will decide, do the facts that have been proven during the trial, do those facts match the definition of the crime? And does the judge need to interpret what the words are within the law to make a decision about whether or not the crime has been committed, or if it's in a civil case, whether there's a breach of contract or whatever. So the judge is going to be interpreting. So we're going to focus on these two words right here. Deadly or dangerous weapon, okay? So a deadly weapon. Now it doesn't tell us what a deadly weapon is in the law. So that is going to require interpretation by the judge. So what is a deadly weapon? What do you think when I say deadly weapon, what do you think of?
A knife.
Potentially a knife, a gun, firearm, absolutely. You know, a nuclear bomb, a claymore mine, a lightsaber from Star Wars, right? My wife's lasagna. Those things are all, no. Her lasagna is all homemade, like hours and hours of cooking, and I can't stop eating it, so I consider it a deadly weapon. It's so good. Homemade pasta, oh, making myself hungry. No, not really. Okay, so a deadly weapon is something that has as its primary purpose the causing of death or injury, as its primary purpose. So like a firearm or a mine or a nuclear bomb or whatever. So a knife may or may not be a deadly weapon, because we have knives for like a pocket knife or something, but you're on the right track. Now, a sword is going to fall into that category. But it says or, dangerous weapon. So there's two different types of weapons that fall within this statute. Again, requiring interpretation. So what is a dangerous weapon? Well, a dangerous weapon essentially is anything physical that could be used to cause an injury beyond what the human body would cause. Something that's going to exacerbate or make worse the possibility of an injury beyond your fist or your foot or your thumb or whatever the case may be. So here, this is what we mean by interpretation. So we had a case here in Oregon, this was decades ago, where there was a guy wearing cowboy boots. And he got into a fight with another person, and he was kicking that person with the cowboy boot, causing an injury by the boot, right, on the person's foot. Now, a cowboy boot is footwear, right? It's not a sword or a gun. So the question is a cowboy boot a weapon? Can it be a weapon? And so that case went to trial, and the person was convicted. They then appealed, and the court at trial ruled that under the circumstances, because the person was intentionally kicking the other person with the boot is harder than the human foot, and therefore, in that circumstance, because it was being done intentionally, the court decided that the boot, in that case, was a dangerous weapon because it created more injury than just the naked foot. And so now that case, a decision by a court, creates this idea of common law, that is judge-made law. Now the way that that works in the real world is when a case is decided, and this depends on what court system you're in. Not all court cases are written down like this, but on appeal they are. So I brought with me, this is from my law library, this is what's called a case reporter. This is from the Oregon Court of Appeals, which is over in Salem. It's our middle level appellate court. And so when a case is decided, in this case by the Court of Appeals, they will write down their decision into one of these kind of books. And that gets published. And now we as lawyers and judges can look at previous cases to make a decision and apply it to a case that we may have in front of us today. And so the cowboy boot case was written down, and the court will go through the facts. Somebody was kicking with a cowboy boot, and because the cowboy boot could cause more injury than just a naked foot, therefore it falls within the definition of a dangerous weapon when it's being used intentionally. And then that all gets written down here, and that creates law. It's a form of, it's not legislating, right? It's not writing new law. So what the court is actually doing, in a way, is annotating or filling in more detail to this law. This law is written by the legislature. So a judge is interpreting this statute, the law written by the legislature, and sort of filling it in. Okay, so it's kind of like the judge is saying a dangerous weapon, which may include a cowboy boot. Now, you're not changing the law, you're interpreting. You kind of see the difference there? And so now that gets written down. So now we as lawyers, when we have another case that comes in front of us, and this is what I used to do as a prosecutor, I would get the police reports, I would review them, and then I would make a determination based upon what the police reports say about what crimes I'm going to allege the person committed. And then we'll take it to trial or a grand jury to begin the case. So, out of the cowboy boot case then, here in Oregon, we have cases that have said that a car key, well, I don't have my car keys in front of me, but a car key can be a weapon. You put it in your fist, you start punching somebody with the car key. This thing right here, a ballpoint pen, could be a weapon, right? Start poking somebody with it. You know, the pen is mightier than the sword and all that, right? Well, in reality, it's true. So a pen can be a weapon. Yes, it's a writing utensil in everyday life, but if I start injuring somebody with it on purpose or knowingly, then it becomes a weapon under this law. We have cases that say a sidewalk can be a weapon, pounding somebody's head on the sidewalk. We have cases that go the opposite way, that say, there's one case, you guys know what Keds tennis shoes are, or sneakers? Do they even have those anymore? That's back in my day. So Keds sneakers, you know, they're little canvas sneakers that you wear. Court said, well, no, that's not really like a cowboy boot because it's just not much more than a foot. So that's not a weapon. So now we have cowboy boots are a weapon, but sneakers are not. So somewhere in between the footwear paradigm, you go from weapon to not a weapon, right? Where do Uggs fall? They still have Uggs? You guys remember those? Probably not, they're pretty soft. Okay, so you get the idea. All right, so let me give you a real world example, a case that I had when I was a DA, this is back in the early 90s. So I had a case involving these two guys going to a bar, right? Sounds like a joke. Two guys going to a bar. So these two guys go into a bar, it's up in Portland, and they're drinking beer. They knew they didn't go in together, they met each other in the bar. They were like friends from high school like 20 years ago. And so one of the guys was a professional fisherman and would go on the bass fishing tournaments. And they were having a bass fishing contest on the Columbia River. And so this particular guy won the tournament. So he got one of those big old belt buckles like you get in rodeo for winning the fishing tournament. So they're at this bar, and they're drinking, and they run into each other, and the guy's telling them about the fishing tournament, and they're sitting at the bar, you got a pitcher of beer, and they're drinking it. They're getting a little bit tipsy, and long story short, they get into a fight, an argument. So the guy with the belt buckle hauls off and whaps the other guy in the face with the belt buckle. Pow! Guy goes down, big old imprint on the guy's face, he had a bruising, swelling. Nothing serious, you know, it healed, but had a lot of bruising and whatnot for, you know, several weeks. We had pictures of it. So the police arrested the belt buckle, the person who hit the person, and charged them with assault in the second degree for intentionally causing physical injury with a dangerous weapon, to wit, a belt buckle. So now I got that case. So I have to decide as the prosecutor, am I going to charge this person with assault too, which is a very serious crime. I mean, minimum sentence is 70, that's 7 times 10 months in the penitentiary, even if you have no prior record. So it's, you know, it's a big deal. So I analyzed it, and I'm looking at it, okay, the guy hit the person with the buckle intentionally, and if a cowboy boot can be a weapon, a metal belt buckle, this thing probably weighed almost a pound, certainly can be a weapon. I mean, you could kill somebody with it. And so I charged them, I took it to grand jury. A grand jury is a group of people that will decide what charges should be filed in felony cases or murder cases. And they indicted the person, and then we went to trial. So we get to trial, and the accused waived a jury, which you have a right to a jury trial in a crime, 12 people. But you don't have to have one. You can say, no, I don't want one. I want the judge to decide the case. And there are various reasons why you might do that. In this case, they did that because it's a very technical thing. The person that was injured, the victim, was very sympathetic. You had a big bruise all over your face, and I think their orbital bone might have been bruised. So the jury's going to have a lot of sympathy, but the technical requirements of the law is what was at issue. And a judge is going to be better about deciding the strict technical requirements than a jury will be. So, long story short, they waived jury, we went to trial, the victim testified about what happened, just what I just told you, and then I rested my case. And there's some other witnesses and whatnot, but so the accused decided they wanted to testify. Now, you don't have to. If you're charged with a crime, you have a right to remain silent under the Fifth Amendment. The burden of proof is on the prosecutor. You don't have to prove you're innocent. You're presumed innocent until proven guilty. And so most of the time, an accused will not testify in a criminal case because you might say something wrong. But in this case, they decided to testify. So the accused got up and testified that they were sitting there at the bar drinking and they knew each other from high school and all that. And they're sitting on, they're sitting on the bar stool, right? And so they're drinking beer, and the guy's got the belt buckle out showing they're a guy. And he admitted that they were having words, but he said, the reason why this happened is I was drunk and I fell out of the bar stool. And when I fell, the belt buckle came up and whacked the guy in the face. All right? So if that's true, does that violate this law? No. Why? Exactly. It was not done intentionally. It was accidental, beer bar slippage or whatever you want to call it. Fell off the bar stool. That's accidental. That's not intentional, nor is it knowingly. And so in that particular case, that person testified. So I'm like, okay, well, if that's true, then they're not guilty. So we have rebuttal, and so I called the bouncer who witnessed part of it, and the bouncer came up and testified in rebuttal. I saw the person who did the striking raise their arm before they hit the other person, above their head. Does that change things?
It does.
It does. Why?
Because in that case, it was intentional.
Because raising your arm shows intent, right?
Yeah, because you raise your arm to strike something.
So they argued in counter to that, when you fall, what's your natural instinct? Yeah. Right? So that's kind of like raising your arm. All right. Are you convinced one way or the other? If you're not convinced, what's that called? Anybody know? In criminal law?
No.
Reasonable doubt. So in a criminal case, you have to prove a case beyond a reasonable doubt. If there is a reasonable doubt about the evidence, then the person must be found not guilty, because the case wasn't proven beyond a reasonable doubt. So the judge is looking there going, okay, well, I have two drunk guys. I have a bouncer who saw half of it. There's a plausible reason why the person's arm came up. Clearly the person was injured. There's no dispute about that. The question came down to intentionally or knowingly. And so there was conflicting evidence. The judge basically says, I don't know. And if I don't know, that means reasonable doubt. Therefore, the judge found him not guilty. Now, I did find him guilty of a lesser charge for recklessly causing an injury. So that was a misdemeanor. So they ended up getting convicted anyway, but of a lower charge. So the point of this whole story or anecdote is this is how a judge interprets the law. The judge will make a decision based upon the facts of the case. The facts are determined and proven at trial by witnesses and use of other evidence, and we'll get into that more later in the term. But the idea is the role of a court is not to write law, it's to interpret the law. And that's what is happening whenever you go to trial. The judge is interpreting, saying, okay, does this particular set of facts, what happened, how do they apply to this law, and or maybe not apply, okay? And then again, over time, we have all sorts of cases. So a belt buckle, and the judge said, clearly a belt buckle could be a weapon under the cowboy boot case theory. But in this case, there's not sufficient proof to prove it was done intentionally. Therefore, the statutory definition was not proven, not guilty. So again, over time, those all get written down, and then we can go research those cases in these law books and use these to formulate an argument when we have a similar case in the future. So if I have a case involving a tennis racket or a skateboard or a book for that matter, right? Could a book be a weapon? And start hitting somebody with a corner of the book? You betcha, right?
Is this something that gives you the advantage in the confrontation?
That's one way of looking at it, yeah. So the original cowboy boot case, the court said it has to be a physical item, not a body part. Because it, like you're saying, it does give an advantage. One way of looking at it. All right, so let me ask you this. What about a dreadlock? Hair? It's an actual case. There was a guy in Portland who had dreads, and he was choking another person with his dreadlock. Now, still attached to his head. So under the cowboy boot theory, the court said it has to be, it can't be a body part. Well, hair is a body part, right? But on the flip side of that, a dreadlock could be like a rope. A rope clearly could be a weapon. That case got pled out to a lower charge, so we don't know the answer to that one. But those are the kind of things that happen in the real world. That's what we have to look at as lawyers to make a decision, prosecutors, etc. All right, so let's move on a little bit here. And let's talk about what happens. This is on page 13, I think. Is that right? My book's off a page number. All right, so when these cases are written down and published, they follow this basic general format. And I want you to have a general basic understanding of how this works. When we do legal research, just like if you're doing academic research or medical research, there are ways that you, like the MLA format for your works cited and that kind of thing. So the same thing in law. It's very detailed. You go to law school, you'll take a whole class on legal research and writing. In fact, I think they have one here at Western. But I'm not going to get into too much detail. Oh, that's way out of focus. I'm sorry. Didn't know this. There we go. All right. So this is a highly abbreviated version of how a court case gets published. Highly abbreviated. And I want you to understand and know some of the components of how this occurs. So first of all, let's look right here, plaintiff and defendant. I want you to know those two terms, plaintiff, defendant, all right? The plaintiff is the party that has initiated the lawsuit in a civil case. In a criminal case, it would be the government that has initiated a prosecution. So the plaintiff is the party that is filing the lawsuit. Now the plaintiff may be called alternatively the petitioner, depending on the type of case, but in this class we're going to keep it real simple. The plaintiff, or the first name, in this one it's Quigley, is the party that initiated the legal action, filed the lawsuit. That will always be the same in this class. Now in the real world, they may switch roles, and I'll get into that later. The second, so you see here Quigley, and then it says versus the First Church of Christ Scientist. That is the second party. The second party is called the defendant, the defendant. So in a criminal case, the accused would be the defendant in a criminal case. The plaintiff in a criminal case would be either the state of Oregon, the United States of America in a federal criminal case, the city of Monmouth in a municipal case. So in a criminal case, it's always going to be a government body. An individual person cannot file in court a criminal case. Only a government can do that on behalf of a victim. Civil court is different. If you are a victim in a civil lawsuit, like an automobile accident, you individually can file the lawsuit. You don't have to have the government do it for you. If you know how to do it, you can actually file it yourself. Literally, you can type it up yourself. You don't even need a lawyer. In small claims court, you can't even have a lawyer. You have to do it yourself. We'll get into that later. But for now, I want you to know plaintiff, defendant. I want you to be able to differentiate between the two. So the plaintiff is the party that files the lawsuit. That will be the first name in the, we call that the case title or caption, versus the second name will be the defendant. All right? So, test question, here we go. This is a real life case. Let me find one here. Here we go. So here we have a case from 1975, Rosensteel versus the State Accident Insurance Fund. So Rosensteel would be the plaintiff, and SAFE, that's our workers' comp, would be the defendant. Now you'll see here it says respondent, appellant. I'm not going to test you on this, but real world, when you appeal from a case, if you lose, when you go on appeal, you're the appellant. And then if you're responding to it, you respond. But you don't need to worry about that, okay? In this class, the first name is always going to be the plaintiff, and the second name will always be the defendant. Let me see if I can find a criminal case for you real quick. So here we go. This is a criminal case. State of Oregon versus Raymond W. Johns, Ralph A. Thompson, and Everett J. Thorin. So the state of Oregon is bringing a criminal case, what is it, a criminal trespass against these three people. All right, so that's the first thing. So I'll give you maybe an example on the midterm. In the case of Bill versus Ted, Bill would be plaintiff, Ted would be the defendant. Simple, all right? All right, next we have the legal citation right here. Let me explain how that works. This is how you tell the judge, well, this is how we refer to where do you find that court case in the library. Nowadays it's all on a computer, but we still do have hard, you guys know what a library is? You ever heard it's like a big building that has these things called books, which are made out of paper? I joke about that because when I was in law school, I went to Willamette, Salem, and this is before they remodeled. And so you go down into the law library, which is like down in the dungeon, and it was so dusty down there. I mean, my allergies just, so I used to make a joke that I was allergic to research. Whatever, right? I passed the bar first time. All right, legal citation. So it works like this. We have a number, in this case right here, let me blow that up a little bit. 65. Then we have an abbreviation for the name of the book, Cal App 4th. Then we have another number. In this case, it's 1027. So the first number is the volume. That is the number on the outside of the book. So if I'm in the law library and I want to go find this case, I'm going to go down and find the California Appellate Court Reporter 4th edition, and they have this all marked on the stacks of books in the law library. And then I'm going to walk down, and they've got hundreds and hundreds of books lining the shelves, and I'm going to pull off number 65. In this case, I brought this from my law library this morning. This is volume 20 of the Oregon, ORAP is what it's called, Oregon Appellate Court. Okay, so simple. So the first number is the volume. That's the number on the outside of the book. The second number, in this case it's 1027, that is the page number. So I pull down volume 65 off the shelf, I then open it to page 1027, and that is where I will find this case in the law library. And that's how we would refer to it in court. That's the legal citation. That's the same for all courts. U.S. Supreme Court all the way down to the Oregon District Court or State Court or whatever court we're talking about that publishes cases. So it's that same formula. Volume, abbreviation for the name of the book, what court it's from, page number. I will test you on that. So I'll give you a citation on the midterm, and I'm going to ask you what those numbers mean. So let's look at a real world one again. All right here. Here we have Ellenwood and Ellenwood. This must be a divorce case. So 20 or app 486. So 20 would be the what?
Volume.
Volume, right? Volume 20. And then the second number, 486, that's the page number right here, 486, where the case begins. So that's how you find it in the real world. All right, now, there's a comma right here. Whoop, excuse me. There's a comma right here, and then we have 76 Cal Reporter 2nd, 792. So that is the same exact case, same words, however, it's in a private publisher law book. The first one's the official government reporter or publisher. The second is an alternative place. You can find the same exact case, but it's a private, usually it's West Publishing or Reuters or Thompson. But it's just the same case, just in a private or alternative publisher, and then they'll add editorial comments to it. So same formula, 76 Cal Reporter 2nd, 792. So 76 would be what?
Volume.
Volume. California Reporter would be the book, and then 792 would be the page. Same thing. Then we have another comma, 1998 California Appellate Court, Lexis document 677. So, pre-Google, the days before Google, I don't know if you remember them or not, but back when the internet was just starting, and we still have this today, but these are legal databases. There's Westlaw, there's Lexis, there's several other ones, and these are online legal search engines, databases, like Google for law. And so this allows us as lawyers and judges to electronically research instead of having to go to the library now. So most of the time what we do now is all electronic. But this would be the site on Lexis, which is a private publisher that does an online legal research database. So now it's really much easier to do legal research than it was, well, really the transition period was the 90s. And so now pretty much everything's done online, makes it a lot easier than it used to be. You had to go read every case and pull the hard copies down, and it was very time consuming. Not so much anymore. So nowadays, if I want to do, like if I want to research when I'm golfing and if I hit the golf ball and it breaks a window on the house next to the course, I can type in all courts throughout the United States. It'll search every single court, hundreds of them, golf ball, broken window. And it's going to give me every case from Florida through Tennessee to Oregon, federal, state courts, where a court decided whether or not you're liable to pay for the window if you tee off and your golf ball breaks the window, and you are, right? So, there's typically insurance for that. But long story short, I want you to know this formula. Volume, name of the book, page number. Volume, name of the book, page number. Don't worry, I won't test you on Lexis or Nexis or Westlaw. I won't test you on that, but just be aware of it. We do have Lexis. The Nexis is the business equivalent for doing business research, and Metis, if I remember, is the medical equivalent. We do actually have a light version of them here online through the Western Library. Okay, next it's going to tell you the year and the name of the court. And then over on this side, we will have the written opinion of the court. So in law, when court cases are written up, or when we do memorandum of law of legal research, we follow this same basic format. Facts, issue, holding, or facts, issue, decision. So the first thing that the court is going to write down in these books are the relevant facts of the case that were proven at trial. So you have a context. What are the facts? So in my cowboy boot case, which I told you about, that's where the judge would write down the relevant facts about what was proven, what was not proven, what was in dispute, where there was not clarity. And so a statement, a summarization of the facts. Pretty simple. As we're going to talk about more next week, facts are very important. The facts will determine the outcome of a case. What happened? When did it happen? How did it happen? We'll get into that next week about how you go about proving facts. But very important, because the whole case will decide upon one thing. Was it intentional? That's a factual issue. Number two, what is the issue to be decided? In our case, there were two issues. The first issue was, can a belt buckle be a weapon? Answer, yes it can. Issue number two, was the cowboy boot a weapon in this case? Answer, no, it was not proven, because there was conflicting evidence, which leads to a reasonable doubt. So that will be written down. What are the issues, and then what was the court's decision? They put excerpts. I like to call it the holding. So facts, issue, holding. If you ever go to law school, you'll have to write legal briefs. This is how you, same format you'll follow. What were the facts? What were the issues? What was the decision? Or if you have to, you may have to do an analysis of your own. It's like an essay question. I won't give that to you. I won't make you do that in this class. That's law school. But all right, so on this page, a few things. Just to summarize, number one, how do you read a case name? Plaintiff versus defendant. Again, real world, they may change names on appeal. You don't need to worry about that. Plaintiff, defendant. Legal citation, volume number, name of the book, page number. And then from the written format, facts, issue, holding. Okay? The two major things I want you to know is how to read the case name and the legal citation method. Okay. Let's go back now to sources of law. On page 3. And we're still talking about judge-made law here. So, at the federal level, we have federal courts throughout the United States, Supreme Court, courts of appeal, federal trial courts are called district courts, and we're going to get into the courts next week and go through them in detail. We also have, at the state level, state courts, and again, we have these decisions like I've been showing you. The book I brought is from the state of Oregon Appellate Court, so it's not federal. So we have these decisions that are made at different levels. So that leads us to the next issue, and that issue is precedence, right here. Precedence. So when we talk about judge-made law, we're talking about these court cases. We have 50 states, so we're going to have 50 different court systems where these decisions are coming from. We also have federal courts, 94 of them. So we have a lot of different courts. So we have all these different courts issuing all these decisions. Sometimes courts come to different conclusions on the very same issue. So how do we know? So how do we know which one to apply and which one is not relevant? So that leads us to this idea of precedence. And that leads us to another term that I want you to know, Latin term. Let me find it here. Page 9, I believe it is. The Doctrine of Stare Decisis. It's kind of early in the day for Latin, but that's okay. Stare Decisis. All right. What does that mean? So, Justice Sandra Day O'Connor, she was giving a speech, I want to say it was Georgetown Law School, but it doesn't really matter. And she said that this is one of the most fundamental and important concepts of the whole United States legal system. the doctrine of stare decisis, if not the most important. So if it's so important, has anybody ever heard that term prior to this class?
No.
Yeah. So what does it mean? Stare decisis, Latin for stand by things decided, or to follow things that have been said, decisis, which is the past tense of the verb, to speak. So stare decisis is to stand on decisions previously decided. In plain English, precedence. You may have heard that term before. What have previous courts decided on similar cases? So here's the general theory. If we have a case in the past that is similar or exactly the same as our case today, a judge today has potentially an obligation to follow a previous court decision involving the same situation, even though there are different people involved. So a judge today, even if it's 50 years later, on a similar case, has an obligation, potentially, to follow a previous court decision. That's what we mean by the doctrine of stare decisis. Judges today should follow older court case decisions. Now, do they have to follow them? Not always. And so this leads us to this idea of precedence. Precedence means from before. So when we have a previous court decision, does it have to be followed in the future? That's the question. Now, this gets a little bit intricate, but this will depend. It will depend upon a couple of things. Number one, if I'm a judge here in Polk County, Oregon, our court's in Dallas, the Polk County Circuit Court. If I'm a judge here, and let's say there's a court case in Iowa, where the court in Iowa ruled that a belt buckle is not a weapon. That's in Iowa. I'm in Oregon. The question is, do I have to follow that decision? In other words, is that decision on the very same issue, is that binding upon me? What we call binding precedence. Do I, as a judge here, have to follow that decision? Or is that decision what we call advisory precedence? Meaning that I am not obligated in Oregon to follow a judge's decision in Iowa, but if I agree with the rationale of the Iowa court, I can decide to go ahead and follow it here in Oregon and adopt that same legal reasoning. So that brings us to the question of, when is a previous court decision binding and when is it optional, if you will, advisory only? And here's how it works. We have levels of courts. The highest level court that we have is what?
The Supreme.
United States Supreme Court, right? That is the highest court in the whole U.S. legal system. When the United States Supreme Court in Washington, D.C. issues a decision, that is binding on every other court in the United States, and sometimes outside of the United States, internationally. If the decision is from a different court, like Iowa, and I'm in Oregon, we're not in the same jurisdiction, then I, as a judge in Oregon, don't have to follow that unless I agree with it. If it's a U.S. Supreme Court case or a higher level court within my own system, like the Oregon Supreme Court, the Oregon Court of Appeals, which are higher courts, then it's binding. If it's from a different jurisdiction or a lower level court than what I am, then it's advisory only. Now, this gets intricate, and we're going to go through all the different courts next week so I can kind of show you a little bit more detail about when that applies. But for today, what I want you to know is this concept of stare decisis is the idea that courts today should follow the previous decisions of judges on the same type of case in the past. You may have to follow it if it's a higher level court, or it may be optional if it's from a different location or a lower level court, binding versus advisory. Now, all I really care that you know is the Supreme Court is binding all the time. When the Supreme Court makes a decision, it binds all lower level courts. Otherwise, you get into it, you have to analyze which court systems you're in, and I'm not going to get that detailed in this class. So, the doctrine of stare decisis is on page 10. The third fundamental concept that begins with the letter S. Again, highly likely to be a fill-in-the-blank question. But also true, false, multiple choice questions, and also on our mind tap, we'll deal with these. Three fundamental concepts. So federal supremacy, which we've talked about already in detail, separation of powers, and finally stare decisis, which is just a fancy Latin term that means follow previous court decisions. All right? Why? Why is it important from a theoretical structural standpoint that judges today should follow previous court decisions? Why? Why can't a judge just say, okay, well, I'm going to make, on this case today, I'm going to make my mind this way, and same case next week?
It makes it predictable.
Predictability, absolutely. That way, we as lawyers and judges and business people, I can read a case and I can say, okay, Supreme Court decided this issue. This is now settled law. We know what to do in the future because we can rely upon that court decision. So that's one, reliability, predictability. The other reason why it's important is equal application of the law. We don't want judges, we want judges to have the same outcomes or same rulings so that law is applied more or less as equal as we can apply it. If we have judges deciding cases from one day to the next on the very same subject but coming out with different rulings, then we're not applying the law equally in a predictable, stable manner. Now, does it always happen that way? Absolutely not. Real world, we know that. But that's the theory behind it. All right, so another issue, Supreme Court. So let's say we have a Supreme Court decision from 150 years ago that nowadays just really doesn't match up with current society or current norms or whatever. Does the U.S. Supreme Court have to follow a previous Supreme Court decision on the very same topic from 150 years ago? Or can they now say, well, we're not going to follow it anymore? What do you think? Talk the U.S. Supreme Court. So the U.S. Supreme Court 150 years ago, whole different group of people than what are there today. Same type of case, same issues, but do they have to follow it today? What do you think? Answer, yeah, you're shaking your head, you're right. The answer is no. The U.S. Supreme Court has the ability to modify or vacate, it's called, a previous decision if it's no longer really applicable as things change. So there's kind of a dynamic quality. This is kind of how law can evolve through court decisions. It's a big debate, legally, how far can courts go and whatnot. We'll talk about that more in a minute. Okay, so the three concepts: supremacy, separation of powers,